Obscening come out challenge so how a G protects Albany. What's cast also Penia, because making headlines, no Jim Rennie be Exum, needing young Braximo, Yambo Ingra, Yin Sim. No, and then Menoka say, High Court, etimi, ama, a ye, EOCO to me, say, a ye, Dennis Miracles, Aboagye, na Jepadibia, a Sefa Tabiano, Omo Emfa, a ye. Tabo emtuso menoka say omonso ayere sa pepepe onia eno ene ye project ye flyer no e dey ato screen so no was say High Court has confirmed an order by EOCO Economic and Organized Crime Office EOCO to freeze the asset of Dennis Miracles Aboagye amid ongoing investigation onia na de eboboba enso ewo eye Dennis Miracle Aboagye asweye enso eno no. Let's talk say yembo ngra yensim fufuro. Aha, AG8 protects Albany.
The point here, if you read everything,
Martin never said that.
He never said it's
Martin, he is not saying. I am saying.
Please stop.
I am saying. Please authority in that. He says the natural conclusion. I agree with him. That's what I'm saying. So.
Hold on.
You are referring to someone as
He's an authority. Martin is an authority.
Because
they study him in criminal. You bring me in our outside. He said rehearing is the normal thing that you should have expected in this case.
If you keep. Because
you should stay on his case.
If you read the counts, a count should be an invitation to offer a defense. So the count must contain an act or omission. Where is it here?
You are wrong.
So please, why am I?
No, wait, for the public's sake.
Why public sake?
We just noted.
A count is not an invitation to offer a defense. A count is a statement that the prosecution must
Mr. Bento.
You see, you don't even know what you are talking about.
Okay. No
so
problem.
if you
So
look
yes.
in the Republic versus Ernest Thompson challenged the charges that were brought against him. The High Court dismissed it. He said the charges were defective. It went to the Court of Appeal. He further appealed to the Supreme Court. I invite you to read my Lord Justice Tanko's reasoning. My Lord Justice Tanko took the view that the charge must contain a certain level of sufficiency to meet a constitutional threshold. The lack of it is not cured by amendment. You strike it out. Now on appeal, if you strike a charge out, everything found on it will collapse. So it is not the charge sheet that was struck out, but specific counts. Those counts that meet the constitutional threshold were allowed to stand. Now, what the judges did, what the judges then did, was now go into the merit, the specific merit of those counts. My senior, what's the name, Martin, raised a very interesting point. Which interesting point had to do with the specifics. The counts. He's done an extremely good job on it. If you pick, for instance, the one bordering on causing financial loss to the states, about the buses, okay? The buses that were...
But for GPRTU?
Were bought 350 buses.
Somebody commits a crime.
Your challenge was that
somebody pays.
he had committed causing financial loss to the states. In the charge of causing financial loss, the fundamental thing that you have to establish is that, in fact, the person authorized payment. Because without it, the charge will not succeed. It is not a charge that is left hanging. The charge must found factual basis. So the justice of the Court of Appeal reasoned otherwise and said, your charge is that ABCD was not done, for which reason you are charging the appellant. By your own prosecution, and guess who the first prosecution witness was? The current MP for Inshiaso, Sticker. He was the first prosecution witness. Now guess what happened under cross-examination of Mr.
Stephen Amwa.
Stephen Amwa. I always still call him Sticker.
Dr. Stephen Amwa.
Exactly. Under cross-examination, Lawyers for, under cross-examination, lawyers for SEDI asked him a very specific question. And also the director of finance was brought in as the fifth prosecution witness, the director of finance of Maslock. So the question was put to him. I'm trying to retrieve that particular portion. Because you see, Alfred, I think that people need to see what is on record. When you see what is on record, if you can still, in the face of those evidence or pieces of evidence on record, still come to a different conclusion, then yours is just not a question of law, but you are looking at something else. Alfred, permit me to read it.
On where exactly? So that, I mean, while we flip through.
No, I'm going to the records, the records of proceedings. Sticker. Okay. PW1. You will see his testimony at page 80 of volume 3 of the record of appeal. Page 80 of volume 3 of the records. Question. You also know from your records that the contract for the acquisition of the vehicles had been signed by your predecessor, but not a single cedi had been paid by Maslock. Is that correct? Answer, yes, my lady. That's sticker.
That no payments were made.
Yes. Now, at page 294 of volume 3 of the records of proceedings, PW5, the director of finance of Maslock, under cross-examination. Question. Your CEO has testified in this court that they renegotiated the entire contract price. Is that the case? Answer. Unfortunately, I cannot speak on my CEO's testimony. Question. I'm asking you personally. Maslock says that the contract price was renegotiated. Is that the case? Answer. From what the person gave to me, yes. This is prosecution witnesses. Now again, at page 297, 294 of volume 3 of the records, question, the same director of finance. This renegotiated contract was done for how many years after A1 had left office? Answer, I have no idea. Prosecution witnesses. Question, but you will be able to tell the court when the payment was made. Is that correct? Answer, yes. Question, when was it made? Answer, 2018. A1 exited office first week in January 2017. Is that correct? Answer, that is correct.
A1 talking about setting a Tamaklo.
Yes. And you people sit here and say that she should be put in prison to make you happy.
So,
what kind of democracy are we running? Now, even shocking.
on what basis? And what do you?
I'm doing merit. I mean, I'll yield to them. I invite you, go to the judgment. Page 85. Please, are you there?
Page 85.
85 of the judgment. And so if anybody tells you that this case was lost on technicalities, the person doesn't even know what he's talking about. Ignorance. 85. Again, PW5, Director of Finance of Maslock, who Godfrey Dami in his wisdom brought to the court as his prosecution witness. When he looked at all the people in this world, he brought PW5 to come and prove his case for him. Competent Dami. Let's see. Question. You tendered Exhibit AD, AC, AB, which relates to payment of end of leave and ex gratia to A1 and her former deputy. Is that correct? Answer. That is correct. Question. The payments were processed by your office. Is that correct? Answer. Very correct. Question. The processing was based on documents relating to the appointments.
Reading court documents.
Relating to the appointment of A1 and her former deputy. Is that correct? Answer, very correct. In processing for this payment, did you notice anything untoward? Question, no. I did not notice anything untoward. Question, you put your signature under this payment because you did not find anything wrong with this payment. Is that correct? Answer, I authorized those payments because I did not find anything wrong with it.
And this is who speaking?
PW5. Godfrey Dami's witness against Sedi. So if you read this judgment, in the face of this, is that the appellate court, even the Supreme Court, going to vary these records when they are bound by it.
I see.
And so, you see, I have listened to people, I've listened to my two brothers here today, and I'm like asking myself, what kind of justice system do we want? The justice system where my brother Richard Ahiagba can even speculate and conjecture and say that it meets a political convenient statement to put somebody in, even if there is no evidence.
There was a question directed
Richard,
at Martin.
what democracy do you think we'll be building?
I see. No. Mr. Agba, no, you want to come.
Yeah.
What was it?
But you know, I didn't have my time to
You say you
make
want
any
to hear
submission.
him. So that,
Yeah, so now it's my time.
What's
It's my
the
time.
issue exactly on what he's talking
Now,
about?
What Aboagye has just done, Aboagye, you made a reference to Article 19(1)(d). Is that what you said? That cures any claim of Section 31(2)?
No, I said the charge sheet must meet that constitutional threshold.
Yeah, so therefore you're saying that Section 31(2) is subservient to 19(1)(d), which, if it's constitutional, is the case. But I don't see it. I just open it. 19(1)(d). I don't see it there. So maybe if you can advise me, because what I read here doesn't say that. So in other words, 31(2)(c), 31(2) should uphold. The situation we see here.
Should I assist? Oh, okay.
Yeah. No, go ahead. No, because it's fundamental.
So
he says that because
I'll do my rebuttal.
I'm coming. No, so I can see what he says, because I'm responding to what he says.
Okay.
19(1)(d). I don't see what he says should be the case there.
Oh no, just give me the context.
You understand? But I'm saying that, Alfred, if we are here committed to fighting corruption, everything my brother Aboagye just read is to the effect that a payment has been made for a commitment of the state to a certain cost. And he says that because it was paid by another person, you understand? And paid by somebody other than the person who committed the state to that payment, then there's no crime. What? Are you serious? Do you hear the sound of it, what you're saying? And then Aboagye makes the argument that governance is a continuum. And so was it expected that necessarily Sedna would have been in office to pay for it when it's a continuum? And another person inherits that contract? And ought to
renegotiate.
No.
But it was negotiation.
Okay.
Because it was bad.
Hold on.
Became what you renegotiate.
No problem.
But
the point here is
What was the
okay, Alfred.
Bring a Foriata.
No problem. Just
the point you made about the inheritance of a particular contract.
That's why you
to the extent that
renegotiated.
the contract was renegotiated,
Yes, it became yours.
and figures changed,
Yeah.
reductions made, and
became
payments
yours.
made. Does that still put the burden on the
It's a
person?
different thing if you had paid on that original contract.
Absolutely.
Hold on, let me finish. does the person who negotiated the contract that you have renegotiated still have the burden of answering for a contract that was never signed?
Alfred, this thing you just asked me. Alfred,
now let me.
Please go ahead.
This question you just asked, does it sound logical to you?
No, what
please.
No. Mr. Agba,
does it sound logical to you? I'm bewildered.
Are you asking a question about the logic of the question?
Yes, because you have to be in a certain frame of mind to ask me that question.
What exactly are you talking about?
Well, I'm coming. Mr. A commits an act that commits a state to a certain payment that is seen as egregious and therefore causing financial loss to the state. Another takes over, identifies the irregularity of it, renegotiated it to save the state money.
Yes.
That action is independent of the original act which committed me to that amount. Are you following the logic I'm trying to advance to you? You commit me to a certain payment. I come in and I charge you for causing financial loss to the state. Then I proceed to mitigate the loss to the state by renegotiating it. And you are saying that the renegotiation I've done should inure to your benefit. When you have committed me to a higher threshold, but I see wisdom and not wanting to waste the state's resources, I renegotiated to bring the price down. And you are saying that because I brought it down to pay a lesser amount, you are saying that you should be absolved from
regrettable.
You see what is happening?
No. I wanted to listen to the logic of your answer. I wanted to listen to the logic of your answer because hold on.
You cancel it.
No, hold on. Yes. Do you know, and Aboagye and Kwebu, you are lawyers, is that not the case?
Absolutely.
Our contract.
I was to come to you, you weren't seated.
I didn't do my submission. I beg you. Oh, you did? No, I didn't. You said something
preliminary. Yes, you made your point.
There was nothing preliminary about it. I just didn't have my time. I wanted to listen to Aboagye. Now, Alfred, just hold on.
And I wanted to understand the logic of your answer, but I still don't get it.
Here's the point. Aboagye and Kwebu are lawyers. I want them to answer for me if contracts are sacrosanct.
Not all.
We in some who it because what channel so. Mammy and I was so jam bread as senator Wadian. Ya dumbi edomini. Unia, Yabishia, na yasan asongo kwan sonko so.